The law was reviewed on it in relation to judicial review, of course, generally being on Wednesbury unreasonable grounds. Lord Justice Maurice Kay was quoted in a previous case where he said reviews against bail decisions such as this were not limited to only rare cases where a judge had gone wrong in an extreme way. They then go through and review more recent guidance in a case I know you're familiar with, Colin, case of Iqbal against Canterbury Crown Court, where a defendant, I think, had been on bail for some time, and then having been charged, I think he was then remanded in custody at his first appearance. And Mrs Justice Carr, as she then was, gave some detailed guidance in relation to this, talked about the fact that the court had weighted his attendance and compliance in the balance, but it was suggested that his bail application had been dismissed without proper reasons. However, Mrs Justice Carr, as she then was, said that the judge's analysis was tailor-made, clear and reasoned. And I think those are three really nice words to bear in mind when giving decisions in relation to bail or when considering bail, that any decision must be tailor-made and the reasons must be clear and reasoned. And I think the Divisional Court would say that the reasons were somewhat lacking in the case of W, X, Y and Z. The reason, of course, that this application was made for bail at this stage was because the defence said there had been a significant change in circumstances. Defence counsel put it rather nicely, I have to say. He said that the evidence of the complainant, because it had now been given and she'd been cross-examined, her evidence was effectively locked in. So in relation to, of course, one of the Crown's objections to bail in relation to interference with witnesses, then that objection couldn't really be substantiated anymore, because what was there to interfere with? The complainant had given her evidence, and as he rightly observed, it was now locked in and couldn't be changed.